No, I just have to stand here and then silence. Good morning, everybody. It's really a great privilege to have you all here in this very inspiring and timely meeting because, as we all know, LGBTI issues are very much under pressure for all the political constellations in the Netherlands and in Europe, and asylum as well. As you have, maybe the guests from Europe haven't seen that there has been a hot discussion on asylum the past days. So the intersectionality of these two issues, LGBTI issues and asylum, and the eligibility process and all the challenges are really what brings us together. And we hope that we will have a very inspiring meeting, but if I have seen all the presentation and the titles, I'm really very in awe. So I'm really looking forward for this day. My name is Domenica Gidey. I'm the chair of this conference. You will not see me very often, just at the beginning and at the end. And I'll just introduce myself. I'm a human rights lawyer. And I have been, I was telling Sabine, coming in and out of activities of COC from 1980s. So I'm a veteran, as you see, great power. And as a human rights lawyer, I have been working on discrimination issues on all grounds. And at the same time also working on asylum, because I was myself an asylum seeker and a refugee in the Netherlands. And as an accompanied minor, I came here many years ago. And I was a translator for the Ministry of Justice and all the departments for more than 12 years in the 80s. And I was telling Andrea Rojas also actively involved on gender-based violence to be recognized as a refugee ground in the 80s as well. So this is my background in the past. And then now at the moment, I'm the vice chair of ECRI, the European Commission Against Racism and Intolerance. And we have come with a general policy recommendation for all the member states of the Council of Europe, that's the 46 member states, not only EU, but all the others as well, dealing on LGBTI issues. And now the governments are going to try to make policy based on our recommendations. So this is for me really bringing all the issues of the works I do together. So I'm very happy to be here. Thank you for asking me. So just a couple of practical points. One is that some of you were asked, all of you have been asked downstairs if you have any objection if you will be photographed. And those who do have received a bracelet so that everyone will know you don't want to be here photographed. The same thing also for the streaming. So that is clear. I hope the photographers know that. And if some of you haven't done it, please, you can go downstairs and ask for a sign so that no one will take pictures of you. Also, the other participants are kindly requested not to take pictures if a person has that kind of bracelet. So that's number one. Second is our guest speaker, Mr. Brian. He has also kindly asked not to be photographed. So it means also that the persons who are here in the room, please not to take pictures or to film his speech, because that's also part of what we are asking for. So that is for the time being. And after the first round of presentation, I will say a couple of words on the workshops. But without further ado, I would like to introduce the chair of COC Netherlands, Astrid Ossenburg. The floor is yours.
Good morning, beautiful people. Yes, I'm always happy to look at a crowd like this, and I feel the warmth. So I'm really honored that I was asked to open this Believe It or Not conference on credibility assessment in Sociesc. I really had to practice on the word because it's really, well, it's very inclusive, but also new for me. So the Sociesc asylum cases. On behalf of the Striking Sirens Coalition, RFSL, Rainbow Migration and COC Netherlands, I wish you a warm welcome and thank you for attending. Both as a person and as a chair of COC Netherlands, I find the topic of today's conference a very important one. Over the last decades, we have pushed for better asylum policies for LGBTIQ plus asylum seekers. I'm gonna say queer from this moment, if everybody is okay with that, because I use queer a lot more than this, because I don't want to trip over my words every time, because the subject is really important. So we have done so by scientific research resulting in 3 prominent reports initiated and produced by Sabine Jansen. And we have done so by, at times, successfully asking the Dutch government to change queer asylum policy. For example, by demanding an end to the use of stereotypical criteria. As COC coordinates the Striking Sirens Coalition, Sabine is also the main organizer of today's conference. And perhaps we can have a round of applause for Sabine's work, for her co-organizer. Thank you, Sabine. Her co-organizer, Jessica van Zadelhoff, and all the others who worked on this conference. It's really important, so thank you all for this. I see the Believe It or Not conference as part of our continuing efforts to improve policy and practice for LGBTIQ+ refugees. Together with allies, together with fellow organizations, and together with all of you attending today's conference. This conference is especially important in the current harsh political climate, in which anti-socialist and anti-asylum sentiments are on the rise. In the Netherlands, rainbow flags have recently been burned and destroyed on several occasions. When a trans woman won the Miss Netherlands election last year, anti-socialist hate messages on social media exploded. In general, discrimination against the queer community is increasing. These are very alarming developments. In Europe, many queer people are now open about their sexual orientation, their gender identity, their gender expression, and their sex characteristics. Sorry, Dutch is my mother language. At the same time, they face more violence, harassment, and bullying than before. And this is especially for the intersex, trans, non-binary, and gender-diverse people. Although worldwide positive steps have been taken in improving the situation of queer people, unfortunately, many queer people around the world still have very good reasons to flee. One dramatic example in this respect is that this year, Uganda imposed the death penalty for consensual same-sex sexual acts. At the same time, nationalist, xenophobe, and racist statements are on the rise. For instance, the current far-right government in this country wants to get rid of national and international asylum law by proclaiming an asylum crisis. This is deeply disturbing for several reasons. One of them is that the populist agenda is not based on facts. As the number of asylum seekers in this country is decreasing instead of increasing, it is merely based on scapegoating asylum seekers for failing national policies. It is equally disturbing that other European countries do the same. Germany wants to reinstall border controls, and racist and/or fascist parties gain support in France, Hungary, Austria, Italy, Belgium, Denmark, and other countries. It is important to realize that the victories and improvements we have achieved over the years for queer people in general and for queer asylum seekers in particular can never be taken for granted. It is important to join forces. We must work together as researchers, asylum lawyers, and activists in order to uphold a solid protection for people who flee their country of origin because they fear persecution based on their socio-esque. And we must fight for policies based on facts instead of prejudice and stereotypes, and for respect for human rights and the rule of law. I wish you all a very wonderful and fruitful conference. Thank you very much.
Thank you very much. Really, the words are so striking of what you said, so I have nothing to add. So let me ask Sabine to take the floor. As Astrid has said, you have played really a crucial role on bringing this topic in the agenda for many, many years. And a round of applause was given, but the second round wouldn't miss. Yeah. Yes.
Hi, everyone. It's a great pleasure to welcome you all in Amsterdam at the Believe It or Not conference. The practical organization was done by CUC, but the ideas behind this conference came from the Striking Sirens Coalition. For those of you who are not familiar with this group, let me explain. It started in October 2017 at the CUC Netherlands Out and Proud Asylum Conference, also here in Amsterdam, where we realized that there were striking similarities in the way in which the authorities in Sweden, Norway, the United Kingdom, and the Netherlands handled the assessment of credibility of socio-esque asylum claims. Previously, in 2013 and 2014, the Court of Justice of the European Union had issued 2 judgments on sexual orientation as a ground for asylum, XYZ and ABC. In the ABC judgment, the court ruled that regarding the assessment of credibility of a stated sexual orientation, explicit questions on sexual practices are not allowed, nor pornographic images, nor decisions based solely on stereotypes. For these would violate the right to dignity and the right to privacy. We, legal researchers from Norway, Sweden, the United Kingdom, and the Netherlands, found that in reaction to the ABC judgment, the asylum authorities of our countries put an excessive focus on narratives of self-realization, expect an internal struggle, an emotional journey, processes of awareness and self-acceptance, the discovery of clear sexual identities, feelings of shame, and other negative feelings about themselves. If the asylum seeker cannot elaborate on these issues, then they run a huge risk that their sexual orientation or gender identity is not believed and their asylum claim is rejected. Following the Out and Proud conference, we held several joint presentations. In 2018 at the ILGA Europe conference in Brussels, in 2020 at the Sojika final conference online, where we found Sofia Sisakou from Greece, who fortunately was willing to join our group. And at CUC Netherlands online conference on LGBTI, asylum and migration. In 2021, we took part in UNHCR's online global roundtable on LGBTIQ plus people in forced displacement. In October that year, we presented our research at the ILGA Europe Online Gathering, and in November 2022, in an online seminar at Lund University, Sweden. Around, or somewhere in between, we thought we could use a name. It was, as a group, it was actually Leanne Macmillan of Stonewall who suggested the name The Smiling Sirens, which we found a bit too sweet. So it became The Striking Sirens. Sometime later, we caught the attention of a donor who proposed to sponsor our work. As this donor prefers to stay anonymous, we cannot tell you their name. But we can, of course, say that we are very grateful, and we would like to thank them a lot for making this conference possible. Please, an applause for the anonymous donor. From the start, our online meetings have been very cheerful. Apart from working hard on this serious and depressing topic, we laugh a lot, and every time our meetings and cooperation provide us with new energy. However, this is the first time that we will all meet in person. In this conference, we hope to exchange ideas and discuss new insights to bring solutions regarding credibility assessment of SOGIESC queer asylum claims closer. In addition, we think UNHCR's 2012 guidelines number 9 on claims to refugee status based on sexual orientation and or gender identity urgently needs to be updated and revised. And this was also one of the conclusions of UNHCR's Global Roundtable 2021. However, to date, the guidelines remain unchanged. Currently, in the assessment of credibility of SOGIESC, decision makers often rely on models and frameworks which are based on presumed universal characteristics of sexual identities. However, it seems to us that these models place too much focus on the emotions and the psyche of the applicant instead of on the risk of persecution. Therefore, we think it's better not to use any models. Finally, it is amazing to see from all your papers how the research on SOGIESC asylum issues developed since the 2011 Fleeing Homophobia report, which I wrote together with Thomas Spijkerboer and 25 experts from European countries. And I found a pile of them in my attic, so you can take them if you like. Although they're 12, 13 years old. I find it very encouraging that so many of you wrote or write PhDs on this topic. I think that the combined efforts of researchers and activists who challenge the repressive asylum practices will take these issues further, and that people who flee persecution will no longer be rejected because stereotypical thinking prevents that their SOGIESC is believed. I wish us a great conference. Thank you.
Thank you very much, Sabine, and Striking Sirens. The name is really wonderful. But I was thinking about Odysseus, but that's something else. We'll talk about it some other times. The most important thing you raised is also because eligibility process of refugee claim is one of the crucial points of having safe protection and security in countries, and understanding that, and understanding how the racialization, understanding of identity, understanding of the intersectionality, this is really crucial. We have it in all asylum cases, but especially on SOGIESC asylum cases are very dire and very important to understand. So really looking forward to listen to our keynote speaker, Nuan Ferreira, Professor of Law, University of Sussex. I hope you will shed a light on this very challenging point. The floor is yours. Thank you.
just one question before I start, if you don't mind. How should I change the slides? Do I need to say when I want the slide changed, is it? All right, thank you so much. Right, good morning, everyone. It's a massive privilege to be here and finally see so many people in person that we meet online for so long. So it seems like Sabina and the Striking Sirens managed to collect here the la crème de la crème of the SOGIESC asylum world. So it's a massive privilege to be in this room. And thank you so much to the organizers for the initiative and for bringing together all these experts and for their kind invitation to have me here. So during the time I have available, I would like to talk about some of the problems that afflict credibility assessment in asylum claims in general and in SOGIESC cases in particular. Oh, all right. It works?
Yeah, my colleague is doing it now. It's a big one.
All right, thank you so much. So I'll be drawing from various projects that I've been involved with and then conclude with some recommendations and possible ways forward. So starting off with some general considerations about credibility assessment, the procedures for the adjudication and determination of the refugee status in many jurisdictions are regulated by a tight web of international, regional, and domestic legal instruments. And in the large majority of cases, the only evidence asylum claimants have and that they are able to produce is their own statements, as we know. And when retelling their story, claimants are simultaneously producing evidence and acting as their own witnesses. And this synchronicity of roles played by the same actor is a structural feature in asylum claims. Asylum claimants are not in a position to request from agents of persecution any proof of their persecutory actions, nor can it be expected that those who persecute will willingly give evidence against themselves. So in this usual vacuum of objective, factual, and documentary evidence, the credibility of claimants' stories becomes a disputed field in the process of asylum adjudication. And while according to the general legal principle of the burden of proof rests on claimants, in asylum cases, the duty to ascertain and evaluate all the relevant facts is shared between the applicants and those who are responsible for examining their claims. Additionally, because of the usual scarce evidential material to support some of the claimant's statements, claimants may be afforded the benefit of the doubt. And as some of you may know, this is my hobby horse. I think very often we forget about the benefit of the doubt, which should be so central in asylum law. The main aim of these rules is to establish a lower standard of proof than the one required in criminal law cases or even private law cases. Yet, the applicability of these rules is subject to the decision maker's assessment of the claimant's credibility. The benefit of the doubt, for instance, shall only be afforded to claimants if and when all available evidence has been obtained and checked, the examiner is satisfied as to the applicant's general credibility, and the applicant's statements must be coherent and plausible and must not run counter to generally known facts, as the UNHCR guidance tells us. Factual and documentary evidence ought to be properly researched and gathered in order to assess the credibility of the claimant's account. Objective evidence, however, may not be sufficient to cover all aspects of claimants' stories. This does not necessarily mean that claimants' statements are contrary to generally known facts. It may simply mean that there are no known facts to support such statements, which may nevertheless be true. It is in this void of corroboration that decision makers are called upon to give claimants the benefit of the doubt and to either allow or refuse their claims. Asylum claimants whose accounts are in fact and in substance credible and are generally at risk on return risk having their claims dismissed. And the credibility assessment exercise is thus a twofold process, subjective and objective. It is subjective because it is a human process, and the human element cannot in any way be eliminated. Assessing credibility involves the handling of facts, not law, and given the lack of corroborative evidence present in many asylum cases, there is always the risk that different decision makers will assess credibility differently. adjudicators' assessment of claims is essentially dependent on their subjective approach to this task, and such degree of subjectivity in decision-making is at odds with the necessary degree of consistency and equality of treatment that should be characteristic of every adjudication process. The issue of subjectivity is thus unavoidable and extremely complex to solve. The objectivity of credibility assessment and of the overall process of decision-making is greatly enhanced by the consideration of objective evidence, such as country of origin information reports, country expert reports, news reports, documentary evidence like arrest warrants, the identity cards, political membership cards, and graphic evidence like photographs, video recordings, and propaganda. However, the boundary between the subjective and the objective in the assessment of credibility is a feeble one. The consideration of objective elements might, to a certain extent, curb the role played by human discretion and thus by subjectivity, but subjective factors still impact on the way objective evidence is subjectively considered. This danger is exacerbated in asylum requests involving SOGIESC. And now we come to the topic of this conference. Considering the deeply intimate and often unprovable characteristics in question, and that past and risk of persecution is likely to be undocumented, relates to one's private sphere, and often occurs at the hands of one's relative or other non-state actors. In SOGIESC claims, credibility assessments tend to focus on whether claimants are members of a certain particular social group, and whether on this account they risk persecution upon return. This emphasis on the SOGIESC identities of the claimants is largely the basis for the acute problems that plague the credibility assessment in SOGIESC asylum claims. This has been documented and analyzed for many years and by many scholars and activists, among which it is of course appropriate to name the groundbreaking Europe-wide Fleeing Homophobia project, coordinated by Sabina Janssen, as has already been mentioned today, and whose cover you can see here on the slide. And more recently, of course, the Striking Sirens who organized this event have unpacked a range of stereotypes in the credibility assessment of SOGIESC claims in several European jurisdictions, like the expectation of having an experienced emotional journey. So much of the work that I have been involved with in the last 15 years has also addressed many of these issues, and I'll be referring to some of it in the rest of this presentation. So as some of you may know, between 2016 and 2020, I had the privilege of leading on a project funded by the European Research Council called SOGICA, which stands for Sexual Orientation and Gender Identity Claims of Asylum. And together with 3 research fellows, Carmelo Danisi, Moira Dustin, and Nina Held, we carried out fieldwork concentrating on the Council of Europe and the European Union, and also 3 country case studies, Germany, Italy, and the UK. The fieldwork was very varied. We had 143 semi-structured interviews with SOGI asylum claimants and refugees, NGOs, policymakers, decision makers, members of the judiciary, legal representatives, and other professionals. We also had 16 focus groups with SOGI asylum claimants and refugees, 24 non-participant contextual observations of court hearings, and 2 online surveys with a total of 239 respondents, including SOGI asylum claimants and refugees and professionals working with them, and finally, freedom of information requests lodged in the 3 country case studies, and with replies having been received in Germany and the UK. Our findings reveal that across all 3 country case studies, there is still a persistent use of stereotypes regarding what it means to be a member of a SOGI minority. There are still widespread expectations about how a member of a SOGI minority should express and experience their SOGI in public, and that asylum authorities still often deny claimants the right to provide clarification of their narrative, which feeds into a culture of disbelief. So far, nothing particularly new. Our participants also confirmed the use of stereotypes relating to how an LGBTIQ plus person should look like, including in terms of clothes and demeanor, as well as the assumption that religious beliefs are incompatible with belonging to a SOGI minority. Decision makers in all 3 country case studies also betrayed stereotypes and Western and Eurocentric values in their expectations that claimants should be out and proud about their SOGI, and these expectations refer to both claimants' daily and personal lives and to claimants taking part in community initiatives and events. More specifically, we identified an expectation that the claimant would have a same-sex partner, a degree of sexual consciousness and experiences, and having undergone an emotional journey, a theme that has been picked up already several times today. Claimants are also expected to have a sexual and gender identity self-awareness according to Western standards and terminology. And most important, it is expected that claimants frequent LGBTIQ plus venues, be members of LGBTIQ plus associations, and attend LGBTIQ plus events such as Pride. All stereotypes that I think we can all agree are not appropriate and should not be in place. And finally, it is apparent that some asylum authorities do not always allow claimants the time and space they need to clarify any possible inconsistencies. Instead, authorities often use inconsistencies to question the claimant's credibility, which reinforces the proverbial culture of disbelief, and this affects particularly bisexual claimants. This pervasive culture of disbelief across Europe understandably leads to anger and frustration, and I guess that anger and frustration make us come to these events and keep fighting this fight. The mindset of many decision makers reflects an entrenched homonormativity which inflicts a terrible violence on SOGI asylum claimants. And as we argued in the SOGICA book, this state of affairs shreds to pieces the principle of the benefit of the doubt and the fairness of the European asylum system. On the basis of the SOGICA findings, there were 2 other issues that came through the data that we gathered and prompted me to write 2 specific pieces of work. One on the discourse of fake claims and another on the discourse on late disclosure. On the issue of the discourse on fake claims, I found it crucial to explore the mechanisms behind the presumption of fakeness that affects SOGI asylum claims across so many jurisdictions. I did that by looking at all actors of the asylum system. It was clear that the discourse of fake SOGI claims strongly influences both asylum authorities, often under political pressure to refuse claims, or hardened by listening to so many terrible stories, and the wider public, swung by populist, racist, and homo and transphobic social trends, as Astrid mentioned earlier today. Perhaps a bit more surprisingly and sadly, I would say, I found that this discourse of fakeness also affects the most unlikely stakeholders. On the one hand, NGOs, support groups, and legal representatives call it upon themselves the right or even the duty to filter the fake claims out of the asylum system, and I always use fake with speech marks. And on the other hand, other SOGI asylum claimants and refugees themselves consider it necessary to identify fake claimants to contribute to the groups that support them and protect the chances of future genuine, with speech marks, SOGI asylum claimants obtaining international protection. So drawing from the work of Fricker, Polhaus, Dodson, and others, I concluded that these dynamics in the asylum system produce high levels of deeply entrenched epistemic injustice. To alleviate the epistemic injustice of the asylum system for SOGI claimants, we need to come to terms with the impossibility of determining the truth in SOGI asylum claims. On the issue of late disclosures, I used a Foucauldian lens, in particular the notions of power and confession, to assess how such instances of late disclosure, again, always using speech marks, are regulated and treated by statutes, policy guidance, and case law, with a focus on the European context. I built on the SOGICA survey finding that 37% of claimant respondents do not submit their asylum claim at the earliest opportunity, and this means that their credibility risks being undermined by asylum authorities. Yet, filing an asylum claim at a later stage can be justified on a range of legitimate reasons, such as the lack of awareness of the asylum process in general, or of the possibility of lodging an asylum claim on SOGI grounds in particular, needing more time to come to terms with one's own SOGI identity and feelings, fearing homophobic and transphobic violence and discrimination, and self-censorship on account of complex social, cultural, and ethnic reasons. Furthermore, filing a claim later rather than sooner has the advantage of potentially affording claimants more time to collect evidence and prepare the asylum claim with the benefit of legal advice. So by using Foucault's tools of power and confession, we can see that the invasive and pervasive nature of confession as a tactic of control of SOGI refugees, including their bodies and souls, by asylum authorities. The asylum system does need to be reformed to rebalance the power dynamics and facilitate voluntary and timely disclosure without the fear of being found non-credible. So after the SOGICA project, I was fortunate enough to have the opportunity to lead on the ESRC-funded project negotiating queer identities following forced migration. It's a project that is still ongoing. It's going to come to an end at the end of this year. And it explores the experiences of people who have left Iran to escape persecution or discrimination on grounds of their SOGI-esque, whom we call queer Iranians in exile. The focus is on 3 country case studies, generally seen as being of transition, like the case of Turkey, destination, in the case of the UK, or resettlement, in the case of Canada. More specifically, the project has aimed to investigate how migration from Iran to the West affects the negotiation of sexual and gender identity and how culturally specific categories such as LGBTIQ+ are negotiated. The project's methodology has included extensive fieldwork, namely 57 semi-structured online and in-person life history interviews in each country, 20 in Turkey, 16 in the UK, and 16 in Canada, as well as 5 interviews in Iran done remotely for safety reasons. We have also used poetry as a research tool because of the strong artistic and folk traditions of poetry in Iran, including elements of queer romance, and its use as a communal countercultural discourse for political dissent. We ran 2 poetry workshops in person in Turkey, 1 online in the UK, and 3 in person and 2 online in Canada, to talk to participants about a familiar poem that they felt expressed their migration journey, exile, and potential sense of belonging or unbelonging to their host country. We also worked with each participant on an individual basis, in person or online, to create short poems that express their journeys, and we've incorporated those poems in our writing up. In relation to the issue of credibility in particular, we found that the asylum adjudication carried out by the Turkish Immigration Office has serious shortcomings. One of our participants, Ali Reza, for example, told us that, quote, "In our time, the UN had a default to truth policy, based on which the applicant was telling the truth unless its opposite was proven. Now, the Turkish Immigration Office is the opposite. Their default is that the person sitting in front of them is lying, and they have to prove that they are not. That is why the interview looks like an interrogation," unquote. This is, of course, reminiscent of the culture of disbelief of the UK Home Office, for example, such as lying as default approach is incompatible with the principle of the benefit of the doubt enshrined in the UNHCR 2011 Handbook on Procedures and Criteria for Determining Refugee Status. The experiences of queer Iranians in exile in the UK also reflects serious issues in terms of credibility assessment. This seems to affect bisexuals, in particular, again, as a consequence of biphobic decision makers. And such biphobia not only erases bisexuals and pansexuals, but it also used to fuel the narrative of fake claims. In other words, a bisexual asylum claimant is an opposite-sex relationship is seen as having presented a fake sexual orientation asylum claim. So to address all these complexities that I've mentioned so far in carrying out a credibility assessment in SOGI asylum claims, there have been attempts, as Sabine also mentioned this morning, to advance models and guidelines that can support the work of decision makers. Many of these attempts are born from a keen desire to find a single method that will enhance the fairness of SOGI asylum adjudication. Unfortunately, these models and guidelines have often been applied in diluted or inadequate ways in order to produce faster and more straightforward decisions. Others of these models and guidelines do not entirely recognize the strong cultural and individual variations that exist in terms of SOGI identity, behavior, and personal development. Moira Dustin and I have explored not only the limitations inherent to some of these models and guidelines, but also the shortcomings in their application in a journal article that came out in 2021 in the Refugee Survey Quarterly. We considered in particular the 2012 UNHCR SOGI guidelines, La Violette's work on the Canadian context, Middelkoop's work in the Dutch context, Shelven's DISH model, which stands for difference, stigma, shame, and harm, and we also considered Janssen's work in the Netherlands. These are significantly different between themselves in terms of their aims and scope, as some provide structured guidance to decision makers to apply on a case-by-case basis, as in the case of the DISH model, and others resemble more a set of principles or checklist of factors for consideration. And these and other differences between these models and guidance provided useful points of comparison. We concluded that while all these models and guidelines have merits, they also have some shortcomings. Most of all, they all focus considerably on membership of a particular social group and the claimant's identity. Instead, Moira Dustin and I argued that we should shift more weight towards identifying the threat of persecution and its source. This can lead to a fairer approach to SOGI claimants, in particular an approach that corresponds better to the principles of the Refugee Convention. Indeed, it is a threat of persecution by state or non-state actors that it is at the core of the claimant's need to apply for international protection. Yet, in many of the experiences of the SOGI refugees that we have met, the persecutory environment is hardly analyzed, with most of the attention being placed on the claimant's membership of a particular social group. Overly sexualized and explicit means of evidence and lines of questioning are no longer allowed across the EU, as Sabina already mentioned this morning, following the judgment of the Court of Justice of the EU in A, B, and C. But there remains a fixation with establishing, or more often denying, that the claimant is a member of a SOGI minority. This fixation leads to experiences that are often intrusive and demeaning to the claimant, especially when discussions take place in the context of appeal hearings open to the public. The ethos behind the principle of the benefit of the doubt should prompt decision makers to adopt as a default position that the claimant is saying the truth, and only reach a negative credibility assessment if the evidence collected requires so. And this should go hand in hand with a greater focus on conditions in the country of origin. We acknowledge that this proposal has serious consequences in terms of resource allocation to the production of country of origin information and guidance to decision makers, but it seems imperative to do so. We were very happy to find out that this journal article had been used by the Canadian Federal Court to support the application for judicial review of a Ghanaian bisexual claimant who had been denied international protection on grounds of lack of credibility. The court noted that, in particular, our analysis of the DISH model, and that although there was much to be said for it, the risk of asylum authorities applying it in a simplistic and damaging way was also materialized, and that the model may have the unfortunate effect of narrowing the mindset of decision makers. So it is motivating to see that this particular piece of research, along other pieces of research out there in this field, have not gone completely unnoticed. But it's obviously a lot left to do to improve the current state of affairs for SOGIESC refugees. So what can we do about it? Can we rely on Europe to save us from this mess? You can imagine the answer. When policies and practices at domestic level produce unfair outcomes, it's very tempting to look at the international and supranational organizations for a source of potential improvements. Can the Council of Europe and the European Union offer us what we need to make the asylum system fairer for SOGIESC refugees? It does not seem so. In a chapter behind me, published in the edited collection Queer Migration and Asylum in Europe, edited by Richard Mole, I have analyzed the jurisprudence of the European Court of Human Rights, sometimes referred to as the Strasbourg Court, to see how it interprets and applies the European Convention on Human Rights in cases involving SOGIESC claims. Unfortunately, I've concluded that the court adopts a dangerously hands-off approach to the scrutiny of the credibility assessment carried out by the national authorities. The Strasbourg jurisprudence's leitmotif in this field is deference towards domestic authorities, something recognized by the court's judges themselves and justified on the basis of the court's subsidiary role and limited tools. This deference is blatant in these decisions that subscribe to a negative credibility assessment. Clear examples can be found in F versus United Kingdom, AN versus France, ME versus Sweden, MB versus Spain, ES versus Spain, and IK versus Switzerland. In all these cases, the court sided with the culture of disbelief of the national asylum authorities, and deference and detachment prevail in these decisions. Even when the court rhetorically highlights that the credibility assessment has to be carried out in an individual and delicate manner, as it asserted in IK versus Switzerland, deference prevails and the domestic authorities' negative credibility assessment stands. A particularly extreme example of this excessive deference can be seen in a case that relates to the Netherlands, MB versus the Netherlands, where the court deferred to the Dutch authorities' assessment of the applicant's credibility, even though the Dutch authorities had expected the applicant to state the number of people involved in a mob attack and the number of police officers who arrived afterwards. In reality, what would have been incredible would be if the applicant had been able to point out exactly the number of attackers and police officers involved in the incident. So the principle of the benefit of the doubt, here I go again, is ultimately ignored by both domestic authorities and the Strasbourg Court. And this unlawfully deprives SOGI claimants of the protection to which they are entitled. So we're not talking about a favor, we're talking about an entitlement. In a good way, of course. In the book chapter, where I explore this body of jurisprudence, I considered jurisprudence until May 2019, and I concluded that both member states and the Strasbourg Court are accomplices in this violence caused to foreign queer bodies in search of international protection. Since then, 2 new decisions have come out in relation to SOGI asylum claimants in the Strasbourg Court. In Rana versus Hungary, a recognized trans-Iranian refugee was refused a gender and name change in Hungary. So the case didn't really relate to asylum as such, it related to the civil change of gender and name. Still, Rana won the case, convincing the court that his right to privacy under Article 8 of the European Convention on Human Rights had been violated, which led to compensation in the amount of 6,500 euros for non-pecuniary damage and reimbursement of costs and expenses in the amount of 1,500 euros. And in B and C versus Switzerland, the court also found that deporting the gay Gambian male applicant without a fresh assessment would be a violation of Article 3 of the European Convention on Human Rights, which prohibits torture or inhuman or degrading treatment or punishment. So the applicant was awarded 14,500 euros for costs and expenses. So these two cases do seem to indicate a slightly more positive trend in the Strasbourg court. So these are positive signs, but I think it's too premature to be optimistic about the court's record, and we need to see what comes afterwards. From the Court of Justice of the European Union, a slightly more positive body of jurisprudence has emerged, and although we cannot say this body of jurisprudence is entirely convincing or positive, it does promote some good developments. In relation to credibility assessment in particular, the 2014 judgment in A, B, and C has played an important role. The case related to gay men from Gambia, Afghanistan, and Uganda, and the court found that asylum claimants' sexual self-identification is not determinative, which is not entirely positive. Sexualized evidence and stereotyped assessments of SOGI asylum claims are illegal, which was, of course, a positive development. And delays in disclosing one's sexuality should not automatically be held against the claimant to harm their credibility, which was also very much welcome. So although the judgment is generally hailed as a positive milestone in the field of SOGI-esque asylum for prohibiting sexualized evidence, and it positively precluded unduly automatically punishing late disclosures, the court failed to place sufficient emphasis on self-identification and did not outlaw stereotyping completely. So stereotyping remains legal to some extent. The Court of Justice was more progressive in the subsequent F case, where a Nigerian gay man had been denied asylum in Hungary on the basis that projective personality tests could not confirm the applicant's self-declared sexual orientation. The Court of Justice rightly found that actual membership of a particular social group may be irrelevant, provided that such membership is imputed to the claimant. And the court also concluded that the tests in question constituted an unjustifiable and disproportionate interference with the applicant's right to respect for private life and are thus precluded by EU law. And, directly relevant to the matter of credibility assessment, which brings us here, the court highlighted that even in the absence of evidence, an applicant's statements regarding their sexuality may not need confirmation, especially if the applicant's statement is consistent and plausible. As Denise Venturi and I wrote at the time in the European Database of Asylum Law blog, although this falls short of relying on applicants' sexual self-identification and makes no explicit reference to the principle of the benefit of the doubt, such emphasis on the applicant's overall credibility reflects a genuine and positive effort from the Court of Justice of the EU to promote fair and lawful asylum decision-making procedures at the hands of the national authorities. So there are positive signs coming from the Court of Justice of the EU, but still much more needs to be done. So where does this leave us? Action is undoubtedly required at multiple levels, including international, regional, and national. At an international level, there have been calls on the UNHCR to revise the 2012 SOGI guidelines and existing training materials, quote, in light of the latest academic, policy, and research findings on SOGI-esque matters and human rights law, so as to ensure asylum procedures are sensitive to the heterogeneity, rights, and needs of SOGI-esque asylum claimants, avoid adopting any model for the assessment of the credibility of the claimants asserted SOGI-esque, and are more solidly grounded in LGBTIQ+ refugees' real-life experiences, unquote. And this was the recommendation, as Sabina already mentioned today, from the UNHCR Roundtable in 2021. In the context of the Council of Europe, it is urgent that the Strasbourg Court improves its judgments as to give the principle of the benefit of the doubt the role it warrants, and avoid excessive deference to domestic authorities in relation to the credibility assessment of SOGI claimants. in the context of the European Union, with several instruments of the new Pact on Migration and Asylum having been approved and published this year, it is unlikely that any positive amendments will be done to these instruments for years to come. Any improvements at the European Union level will need to be introduced via the jurisprudence of the Court of Justice of the EU or institutional policy and non-binding measures. Several of the SOGICA project recommendations to national authorities are particularly relevant for the issue of credibility assessment. And these include not discriminating against late disclosures, decision makers not asking whether claimants are truly LGBTIQ+, but only whether they are likely to be persecuted on SOGI grounds if they were to be returned to the country of origin, respecting the correct standard of proof, including the principle of the benefit of the doubt, and sharing the burden of proof with asylum claimants, not making use of stereotyped notions, neither during the interviews nor in the decisions, taking the evidence, particularly the personal testimony, submitted by claimants as the starting point for credibility assessment, and adopting as default position a belief in claimants' accounts of who they are and what has happened to them. Together with Denise Venturi, we have also advocated for a three-pronged non-legislative strategy focusing on much improved training and guidance and quality control. This should incorporate the input of refugee and LGBTIQ+ groups more familiar with the issues in question. And as Moira, Dustin, and I have argued, rather than adopting models or templates, decision makers should be encouraged to adopt open questions such as, what do you fear would happen to you if you were returned to your country of origin? Claimants' answers could then be compared with the country of origin information available on SOGI minorities in the country of origin in question, and unless there are discrepancies that cannot be explained, refugee status should in principle be granted. This approach can help avoid an excessive focus on the claimant's true SOGI or stereotypes. Finally, I would like to suggest a bolder, more unconventional approach, which is to rewrite the law ourselves. Just take it upon ourselves to do it, since nobody else seems to be able to do it. So together with Maria Moscati and Sen Raj, I've been having the pleasure of coordinating the Queer Judgments project since 2021. And this is a project that is very much in the vein of past judgment rewriting projects, like the feminist judgments, the Earth Law judgments, the children's rights judgments projects, and so on. So we embarked on this adventure of reimagining, rewriting, and reinventing judgments from a queer or other complementing perspectives that affected SOGI-esque matters one way or the other. Soon, our edited collection will be out with counterpress, and it will include 26 judgments and commentaries with an international reach and multidisciplinary scope. Amongst these judgments and commentaries, you'll be able to find two that change the narrative and challenge the case law on SOGI-esque asylum. One contribution by Alex Powell, right there, so if you have any questions about that contribution, have a chat with Alex. And Alex revisited the judgment of the UK Supreme Court in AJ Iran and HD Cameroon. And another contribution by Carmelo Danisi and myself that revisits the judgment of the Court of Justice of the EU in X, Y, and Z. Both these contributions offer a queer and human rights counter-judgment that goes much further than the originals and avoids the traps of homonormativity, homonationalism, and restrictions on sexual diversity. This way, we can clearly show how judges can produce better decisions that do more justice to SOGI-esque asylum claimants. So in conclusion, we need to frame the credibility assessment process and the construction of the notion of particular social group in a way that, as Samuel Balin argues, quote, accommodate the diversity, complexity, and fluidity of claimants' lives, unquote, and allows for universalist and essentialist categories to be challenged and contested. After all, fluidity, ambivalence, and experimentation should not be an exclusive privilege of those with permanent residence permits or citizenship of the host country. And we need to resist the asylum system's wish to categorize and imprison queer people's ever-changing, blurred, intersecting, and unruly identities, as Samuel Balin and Irene Maganini is around here as well, in their words, and they rightly assert that this is a freedom that should belong to everyone. For claimants to be able to narrate their stories in their own anti-hegemonic terms and prevent misunderstandings and re-traumatization, asylum systems need to offer claimants interviews that are trauma-sensitive, non-violent, and attuned to the difficult circumstances that asylum claimants face, to use Ada Schwank's words. A whole body of queer scholarship is out there, underpinned by strong anti-identitarian and anti-normative elements that can support us in this journey. These should be complemented by adequate consideration of psychological research into human memory and responses to trauma, and to ensure decision makers are aware of the impact of applicants' psychological state and cultural differences on testimonies and offer more transparent and fairer outcomes. So believe it or not, we have the tools. Now we just need the political will. Thank you very much.
Thank you so much for your thorough presentation and really thought-provoking. And I was very happy also for the calls to action. That's something very important as well, and durable calls of action, which will really not only ticking the box, even though you ended with with a model, but in a way that are really going to change the system, because that's really what is very difficult in asylum. As you said, the benefit of the doubt that that's not the standard way of doing things, and the credibility issue in which the default state is the disbelief. And also that there is a fear that when you will be flexible and really humane in a way we approach in a trauma-sensitive, informed way of dealing with the asylum cases, it will have the impact that more people will ask asylum, and then our countries are going to be flooded. So this kind of discussion makes it very challenging how to be human, how to be human rights informed to do things. And I hope, coming from the council, that the court finally will understand this, the work you are doing, and I will try my best at least to put forward all the presentations and information you have shared here. So thank you very much. And there is a possibility to ask questions at the end in the afternoon when we will be sitting together. So that's a really important moment to share together. Thank you. So now it's time for our next speaker, Brian. You are a refugee from Uganda. And as I said before, please refrain from taking pictures. And the floor is yours to share with us what you'd like to share with us about your lived experience, and also maybe challenging us to take certain action. The floor is yours.
Hi, good morning. I'm Brian, and I'm a little bit nervous. I've been in hiding for so long. Believe it or not, I really don't know how old I am. I was told I was found on the 21st of June, 1980, in front of the village chief's door with another baby who was already dead. Sorry. She died because of the coldness, and I was raised in that family with 11 girls, whereby I was not treated well for all those years, 11 years, and I had to run away to the streets of Kampala. And I stayed on the streets for more than 9 months. Looking for what to eat was the hardest thing. And I remember one day, as I was looking for what to eat, I was terribly beaten to death. But I was taken to hospital before I died. At least I'm still alive. And when I woke up, there was a gentleman just sitting next to me on my bed. He told me he's the one who called the ambulance. He's the one who found me and called the ambulance. At least he brought food. He cared for me. He brought everything I had to use until I recovered from the hospital. He took me to his home. He paid the hospital bills and took me to his home. I stayed there for 2 or 3 weeks. Then took me to his friends. They were the ones who had to pay my school fees and look after me. At least they gave me shelter. I found in that place where he took me, I found other kids who were around my age from different cities of Uganda. But in exchange, we had to do some jobs for them. And the job was prostitution. We were trained on how to handle the customers. And if you are not willing, you were asked to leave the compound. The compound was divided into 2, the girl side and the boy side. It is in that period that I realized that I'm gay. My feelings grew stronger and stronger every day towards the boys, and I was always aroused during the football, during playing with other kids. The feelings grew stronger and stronger. But within that period, we had some people coming in. Since we are from the streets, they had to give us some trainings on how to behave in the people when you go to the people. So some people used to come in and counsel us on how to behave. And among them was one gentleman called Kato, who after some time I tried to go closer to him and I explained to him how I was feeling. Kato explained to me that it is normal, that he was gay too. So from time to time, I had to talk to Kato almost every time he came in. He had to look for me and we talk. He advised me on different things. Then one day in 1995, the place was raided by police. Most of the kids in that place were killed. Those who ran away were burned by the people around. Those who were known were killed, most of them by their parents, because being a gay in our cultures is regarded a grave sin and a curse. So, when I was coming back from school, the raid took place when I was in school. I was coming back from school. I saw what is going on. I had to run. But running, I didn't know where to go. Seeing your friends burn, holding the tears back, such that you hide within the crowd, was not easy. I had to search for the one person I knew who was Kato. As I was staying on streets, I used to go to a place where he had directed me that he used to hang there. And eventually, after some time, maybe 2 or 3 months, I found him. Sorry, I've been keeping this for so long. When I found him, he also told me he had lost a lot of his friends. Some had gone to prison. He managed to survive that period also. Meanwhile, from the school where I used to go, because when I ran, I had to hide, but during the day, I go to school. I tried as much as possible to continue schooling because it was my only hope. So at night, I used to sleep on the streets, under the bridges. Then during the day, I go to school. So one of the teachers realized, and she came to me. She told me, and she discovered that I was gay. She told me she could help with the treatment because for her she believed it is a curse. And curses can be solved. As I explained this to Kato, Kato told me, no, you are normal. So imagine at that age, I was 15, I remember. I'm trying to fight with two ghosts. One is saying I'm normal, another one is saying it is a curse. I didn't know who to believe. So I tried to believe what the teacher was saying, that she could help. And I went with her to a doctor who I know he was a witch doctor. I was shot with an injection. I have a mark in my back, which paralyzed me for almost a year. I had to do my final exams that year using sticks. I could not walk anymore. But after some time, nothing changed. I stayed the same, and instead just grew stronger and stronger in me. And whenever I could see male, my feelings were more strong. So I realized it the hard way, that being gay is not a curse. Kato did not have enough money to keep both of us. So I had to be going on streets, selling what I could sell to pay for my school fees. For him, he could just give me shelter, sometimes food, but school fees was on my end. After some time, I had to go to high school, and eventually I was 18. But also in high school, I had to look after myself, selling things on the streets, because that is what I knew. But I had a lot of challenges. I faced a lot of bullies in school because I was very poor, very, very poor. At school, I had one person who always defended me in whatever situation. He almost bought everything I had within the day. And he later became my first love. He was called Edward. We had to hide this because it is a sin in my country to be gay. We went on for a long time, and eventually time came and he had to go back to his country, which is Rwanda. He was not a Ugandan. I followed him. I stayed there for some time. He was called by his father, was staying in UK, and I had to come back to Uganda. I did my best and joined university, still doing the same jobs on the street. But when I joined university, I did something different. I had to teach myself on how to use computers, and I taught it to other students who needed help. I did their homework, I did their dissertations, I did everything I could just to collect school fees for myself. And I graduated in 2004 with a degree in social sciences and a concurrent diploma in education. They were supposed to be 2 degrees, but they were not given. And I was retained to be a junior lecturer in the university. Edward came back from UK, and I had to go to Rwanda. I met him, we talked, but that is a period within that age that families in Africa organize marriages. So his family had organized a marriage for him. We talked about it, and it was the only way to keep our relationship safe. He gets married, that was a cover. It really hurt, and I don't know how to explain it to you because there is no words to explain that. No. I felt pain on that day he got married. And it drove me crazy. And for the first time in my life, I went in a bar and drank, completely wasted. So I just, after drinking, I went back to my car and just drove off. I don't know to where. But in the morning, I woke up in the bed with a student who was in my house. The university had given me a big house, a very big one. So in that house, I used to help the foreign students who didn't have where to sleep to use my house since I was not always there. But one of the students never left. She was always there. So time came and I asked her, oh, how come other students are leaving and you are not leaving? Her story was touching also, because she was running away from a forced marriage in her country. She was from Somalia. So she was the one who helped me when I came. I had knocked the car. I came in wasted. She helped me out of the car. And I realized I used her in the morning because of the anger inside me. So I told her she could not stay. It was not safe for her. I gave her some money and told her to leave. But after some months, 4 months, she called me and told me she's pregnant. I had to take responsibility. I called her back. I rented for her a home. But unfortunately, the baby died before it was born, so it was a stillborn. She was physically injured. She got fistula. I don't know if you understand fistula. So she was not really well physically. Now, I don't know if you remember the teacher I told you about who took me to a witch doctor. She started blackmailing me that if I don't pay her, she's going to tell the public that I'm gay. So I had to pay this teacher every month just to keep silent. For some time, I tried to talk her out of it. She refused. Kato tried to talk to her. She refused. And time went on. In 2009, 2010 in Uganda, the hunt for gays started. Begin this time it was really hard for any gay to survive. It was really harsh. A lot of people were published in the newspapers. A lot of people were killed. A lot went to prison. It was within this year that Kato was killed. He was the only person I knew who was like a father to me. And this scared me. I felt alone. I had to tell my wife the truth about me. She didn't believe, she got angry. And by that time I had a job in South Sudan. So, in this bitterness, I had to go to the job and stayed there, but after some time my name came out also. But since she also had nowhere to go, she had to stay. So she called me that your name is out. Don't come back. She helped me to go to Somalia. I stayed in Somalia for some time, but I had to come back because by the time I left Uganda, we had a child. So I came back. I faced some security issues, too many security issues. Then one day I received a call from one of the majors in Uganda. He knew about me, and he told me if I don't do what they want, he was going to tell the public, one, since I was coming from Somalia, I'm working for Al-Shabaab. Al-Shabaab, I don't know if you know Al-Shabaab. Yeah, I'm working for Al-Shabaab. And I'm gay. Remember, I'm married to a Somali. So it was impossible to escape this. I remember one day I failed to go to one of their meetings, and I was terribly beaten. With my wife, we were left unconscious. My wife was pregnant by that time. She gave birth to a baby. Up to now, the baby is still disturbing us. The baby has infections. All in all, I can summarize this like my life as a gay, by that time, it became a threat to most people. I was blackmailed. I was told to do things that I was not even, how can I say this? Because the security wanted me to pin things on people who didn't do anything. Just naming a person that this is a terrorist, just because I'm gay. So I had to find a way to run out of the country. In 2019, I came to Netherlands. I was questioned 3 times. I faced through the interview 3 times with 3 different interpreters, and I got a rejection. I didn't know what to do. I give thanks to my lawyer. She didn't give up on me. No. Marion, thank you. Thank you so much. I really didn't know what to do. Thank you. I&D expected me to talk more about my personal extensive way about how I was feeling when I was 11. Imagine. I could not even. They asked me what it did to me that the teacher thought homosexuality was a curse. I was 15, and I didn't know, is it a curse? Is it real life? The society tells you it is a curse, but I indeed did not believe what I told them. So, even my wife wrote a letter, but they didn't put it into evidence. They didn't take it as a support document. Until my lawyer appealed, and we went to the court, and the court, the appeal, the court thought that I indeed should have considered the circumstances that I was 11 when I realized that I was gay and grew up as an orphan. In this situation of coercion and abuse, they should have believed that. The IND said that I declared vaguely and briefly on the way I realized my sexual orientation, but the court missed the IND's explanation, why they would expect more of me on this point. There's no reason to expect from people with good education that they will declare more throughout their feelings and sexual development. Thank you so much.
Thank you so much, Brian. It leaves us speechless, but this is a very important account of experience, of the layerness and the complexity of a person's life. And then, as you had said, about the credibility issues and the impact it has in someone's life. So thank you very much. We are now going to have our next speaker, and after her, we will have a break, so I think we are asking a lot from your attention. I would like to ask Andreas to approach, and from the UNHCR, as we have said, we have expectations from the UNHCR, and you are the focal person for refugee claim based on diverse SOGIESC. So the floor is yours. Thank you very much.
Thank you so much, and thank you, Brian, for your testimony. Indeed, it's very touching to hear the first-hand experience of a refugee, so thank you so much for sharing your story with us. And so it's a great pleasure for me to be with you today on behalf of UNHCR and participate in this conference on this very important topic. UNHCR strives to ensure that all individuals fleeing persecution in their country of origin have access to fair and efficient asylum procedures without discrimination. The UNHCR High Commissioner for Refugees has long recognized the unique vulnerabilities and specific needs of persons of diverse sexual orientation, gender identity and expressions, and sex characteristics. Persons of diverse SOGIESC often flee their home countries due to severe persecution based on their real or perceived diverse SOGIESC. This persecution can manifest in many different forms, including physical violence, psychological abuse, discrimination in employment, housing, being ostracized by their communities, and are often escaping environments where their very existence is under threat. In recent years, we have seen an increase in homophobic attacks, and we are witnessing a proliferation of legislation criminalizing same-sex relations or non-conforming gender identities, leading to arrests, imprisonment, and severe mistreatment. For LGBTIQ+ people in forced displacement, the journey to safety can be fraught with danger, and upon arrival to the country of asylum, they may encounter further challenges, including discrimination and lack of understanding from the national authorities and the asylum seekers community around them. The 30th of September, which is not too far away, will mark the 14th anniversary of the first UNHCR Roundtable on Asylum Seekers and refugees seeking protection on account of their sexual orientation and gender identity, which led the way to the development and the issuance of the Guidelines on International Protection number 9 on claims to refugee status based on sexual orientation and gender identity. UNHCR uses guidelines on international protection as part of its mandate, fulfilling its supervisory role, providing interpretative guidance on the provisions and terms in international refugee instruments. These guidelines aim to offer legal interpretative assistance to government, legal practitioners, decision makers, as well as the judiciary. The publication in 2012 of the Guidelines number 9 served an important function by solidifying UNHCR's earlier guidance on refugee claims relating to sexual orientation and gender identity, and unambiguously stating the principle that persecution on the basis of someone's diverse SOGIESC is a legitimate basis for seeking international protection under the 1951 Refugee Convention. We are cognizant, however, that the guidance must be accompanied with a practice that would in fact guarantee persons of diverse SOGIESC access to fair asylum decision-making. And this brings us to the core of our conference today, credibility assessments in SOGIESC asylum claims, and the importance of avoiding stereotypes and biases. And we hope to achieve this through a fact-finding methodology to establishing material facts of the asylum claims. Saying this, UNHCR also acknowledges that credibility assessments process in SOGIESC claims must be handled with the utmost sensitivity and care. UNHCR advocates for states to implement fact-finding methodologies in establishing the material facts of the asylum claims, and for each case to be assessed individually, taking into account the personal circumstances, experiences, and specific protection needs of the LGBTIQ+ asylum seeker in front of them, and ensuring that their claims are evaluated fairly and accurately. A methodological approach aims at reducing the subjectivity of the credibility analysis, subjectivity that we have heard from the presentation of Professor Nuno Ferreira, and focus on the specific material elements of the individual asylum claim, assessing the credibility of the applicant's statements with regards to those material elements of the claim, and those elements only. SOGIESC asylum claims are not different from any other asylum claim and should be held up to the same standards in the application of the credibility indicators, which I'm sure are known to all of you: specificity and sufficiency of detail, internal consistency, consistency with other sources of information, including country of origin information, and plausibility. And of course, bearing in mind the standard of proof of balance of probabilities. One of the key principles outlined by UNHCR is the avoidance of stereotypes and cultural biases during the credibility assessment process. Decision makers are urged to approach each case with an open mind and refrain from making assumptions based on preconceived notions about LGBTIQ+ individuals and their respected lived experiences. This includes recognizing that not all LGBTIQ+ individuals will conform to stereotypical behaviors, appearances, or preconceptions of what a genuine queer experience should look like. Equally important is to take into consideration the individuality and cultural diversity of all asylum seekers. However, to reach a sound and well-sustained finding of facts, it is also important for the decision maker to rely on the most relevant and reliable information. This, of course, is the applicant's testimony. Mindful that the applicant's testimony is the primary and often the only source of information in the refugee status determination procedures, interviews must be conducted in a sensitive manner. Confidentiality and respect for the dignity of the asylum seeker is paramount in this process. UNHCR promotes the implementation of the peace model of interviewing to achieve this goal, as it has been adapted by UNHCR to the humanitarian context. This model draws on the theory and practice in the field of cognitive and investigative interviewing, and it presents tools and techniques which interviewers may use to facilitate communication and assist individuals in providing information at their own pace and in their own words, resulting in the most reliable, detailed information. Interviews should be conducted in a manner that ensures the privacy and safety of the individual. This includes using appropriate language, being mindful of the individual's emotional state, and providing a supportive environment where they can share their experiences without fear of judgment or reprisals. Decision makers should take into account the difficulties of LGBTIQ+ individuals may face in disclosing their diverse SOGIESC, and late disclosure should never be considered a negative credibility finding. So how can we achieve this? It's the million-dollar question. Asylum officers, caseworkers, other officials that are involved with the asylum process must receive specialized training to understand the specific issues faced by LGBTIQ individuals. The asylum process does not start when the claimant walks into a room to undergo an RSD interview. It starts from the moment they first approach the national authorities to seek asylum and to lodge their asylum claim. To ensure that the credibility assessment process is conducted effectively, it is essential to strengthen the capacity of professionals involved in the asylum process and beyond, at all levels of the process. This includes border guards, lawyers, social workers, volunteers, and so on. Anyone working with asylum seekers and in the immigration sector should be well equipped to understand the rights of LGBTIQ+ individuals seeking asylum, both in terms of substantive and procedural aspects of their claim, as well as the specific needs and challenges of LGBTIQ+ asylum seekers. Official tasks with determining refugee status and managing reception conditions should receive such training, and they must be sensitive and culturally appropriate regarding sexual orientation, gender identity, and sex characteristics. This training should encompass conducting individual assessments that are attentive to the protection needs of LGBTIQ+ individuals, utilizing interviewing techniques and assessment techniques that uphold the dignity and privacy of asylum seekers. These techniques should be objective and sensitive without the stereotypes and cultural biases. UNHCR is committed to continue working with the states in developing their national asylum systems, in reinforcing their capacities and strengthening their RSD processes to ensure the right to seek asylum is upheld without discrimination of any type. Now, the guidelines number 9, which is one of the burning topics in this conference. And as we have heard already today, and we'll certainly hear throughout the conference today, there is a need to adapt the guidelines number 9 to today's reality. The guidelines number 9 were issued in 2012, which is 12 years ago, and our understanding of sexual orientation and gender identity has evolved considerably, or society has evolved. However, and I'm sorry to say this, but the update of any of UNHCR's guidelines on international protection is a challenging task. UNHCR has indeed initiated already a process of conducting an evaluation on the guidelines on international protection. However, this must be taken as a holistic process, as many of the guidelines touch upon similar concepts, and many of them have been issued over a decade ago. It's not just GIBS number 9, which needs a touch, I would say. And we need to look at all of those together. This is not an easy feat, and will certainly not be a quick either. UNHCR, I'm sorry to say this as well, but it's a bureaucratic, slow-moving organization, and it will take time to achieve that goal. However, when the time comes, such process will be an inclusive and consultative one, with the engagement of stakeholders, civil society, academia, and the affected populations in particular, for the GIBS to be reflective of our current realities and the state of law. So when the time comes, I do hope we'll count on all of you to participate in this process. And, but this is not to say that there's no hope with regards to the evolution of our guidance in this regard. We have witnessed indeed an evolution in our understanding of SOGIESC claims themselves. And this has manifested already in diverse of UNHCR's court interventions, which go beyond the GIPS number 9. Through UNHCR's judicial engagement, we do hope to continue collaborating with organizations such as yourselves and legal practitioners to ensure the rights of LGBTIQ+ asylum seekers and refugees are upheld. If a case comes to your attention, this is our big ask, and I have to say, maybe it's a bit pretentious from UNHCR to come to a conference like this and ask something from you. But if you are aware of any case that you think would help or support, please do flag it to us. In your countries, from whichever country you have flight from, you can reach out to our representation there and flag the importance of the cases that are being heard before your jurisdiction, so we can also support in the intervention. So I have to say that these presentations that I will be hearing today, will be very valuable, and certainly will be a source of inspiration. And I look forward to hearing all of you today, and to take with me also lessons learned that we could also implement ourselves in our own RSD procedures under UNHCR's mandate. Thank you.
Thank you very much for your humble and also very open explanation about the situation, about the bureaucracy of UNHCR, and at the same time giving hope that by court intervention there are possibilities in the meanwhile to be of help, and also call for all of us here to be aware of that possibility, and maybe that UNHCR can compile certain court intervention they have had and then put them on the site to show that there is progress in the meanwhile. So you see many organizations doing that, that can be helpful in the meanwhile. Dear participants, we have asked a lot from you to really listen so much and with so much attention. So it's a human right to go to, I called 2 persons who were going downstairs to come in the room while they wanted to smoke. So it's a tea break. And let me see at the time, how much time I'm giving. Oh, it's not much. We were supposed now to stop with our break, so is 15 minutes reasonable time. So it means it will be taken away from the time for the working groups. So it's 11:05. To please go to the working groups you have assigned to, and everyone has received a colored card with the working group number in which you are going to, and one is here. There are 2 in here on this in the hall, and downstairs there is also a working group. So please come back on time, because we really want the participants who have really presented wonderful papers to have the opportunity to share them with you. See you later. Thank you very much. Yes?